Welcome, everyone, to our program today on the U.S. Supreme Court, voting rights and the threats ahead with Erwin Chemerinsky, who is the Dean of Berkeley Law. I'm Laurel Plimier, and I'm the president of the League of Women Voters of Piedmont in California. And as always, I want to thank you all for taking some time out of your day to spend with us here today on Zoom and on YouTube. This event is part of a larger Defending Democracy speaker series. We're fortunate to have a number of local leagues across the country who are co-sponsoring this series with us. Collier County in Florida, Gunnison Valley in Colorado, Oakland, California, the Pikes Peak region in Colorado, Portland, Oregon, Pueblo, Colorado, Santa Barbara, California, and Solano County, California. And we, of course, appreciate your support and welcome to the members from those leagues who are here with us today and their guests. And I looked at our registrations yesterday, and there were 22 different leagues who represented 6 different states in the country. So that's pretty exciting for us. And thank you for joining us and learning with us. You might have seen our first 2 events on voting rights and on ranked choice voting. And if not, you can find a recording of those events on our YouTube channel, and there are links for those on our website also. And we have 3 additional events coming up in this series. After today, the next event is Can American Democracy Survive? An International Perspective with Fiona Hill, and that'll be on March 30th. We have Election Subversion and Disinformation with Rick Hassan on April 5th, and then a more California-centered event about getting out the vote in the Central Valley with Fonda Karelitz and Shannon Edwards, who are with Central Valley Matters, and that'll be on April 27th. And you can find out more information about all of those events and find the recordings of previous events and this one after it's recorded at our website, which is lwvpiedmont.org. So, and just quickly before we get to the introduction of our speaker, I wanted to go over a few logistics. I'm expecting that many or most of you are familiar with the Zoom webinar features. Feel free to introduce yourselves in the chat if you'd like to, and if you want to ask a question for Dean Chemerinsky, you can put that in the Q&A, and we'll get through as many of those as we can in the second half of the program. And if you're watching on the Zoom live stream, you can post your questions in the live chat there. And if you are watching on Zoom, or if you're watching a recording of the event at a later date, please subscribe to our channel. And if you click the bell, you'll get notifications of future live stream events. If you want advance notice of future events, please join our mailing list, which you can do on our website, which again is lwvpiedmont.org. And you can also become a member of the League there. Your dues alone support the grassroots efforts of the League, both locally and at the state and national levels. And if you visit any of the event pages for this Defending Democracy series on our website, you can see the logos for our co-sponsors, which will take you directly to their leagues. So if one of them is local for you, you can join their local league that way. And you can also find a local league by going to lwv.org, which is our National League's website. The League's efforts in voter education and advocacy are extremely important work, and we really appreciate your support. So now I'm going to turn things over to Nancy Beninati, who is our voter service chair and past president for the League of Women Voters of Piedmont. And she's also a deputy attorney general with the California Department of Justice, where she's been for the past 20 or so years. So Nancy, off to you.
Thank you, Laurel. As Laurel mentioned, Erwin Chemerinsky is the Dean of Berkeley Law, and he's the Jesse Chopra Distinguished Professor of Law. From 2008 to 2017, he was the founding dean of the University of California Irvine School of Law. He has also authored 14 books, his most recent being Presumed Guilty: How the Supreme Court Empowered the Police and Subverted Civil Rights. I have to get that book because as the supervisor of the Racial Identity Profiling Board in California, it is right up my alley. So I look forward to reading that, Dean Chemerinsky. And I also want to say that I have had the pleasure of hearing you lecture on constitutional law. So I can tell the folks in the audience today that we are all in for a real treat. So without further ado, please join me in welcoming Dean Erwin Chemerinsky to the League of Women Voters Defending Democracy series.
Nancy, thank you so much for that very kind introduction. It's really my honor and pleasure to get to speak with you. American democracy is in grave danger. What we saw in late 2020 and early 2021 has no parallel or precedent in American history. The core characteristic of democracy is that there's the orderly transfer of power based on the outcome of elections. This was the first time that an incumbent president had been defeated and refused to leave office and did everything that he could within the bounds of the law and outside the bounds of the law to on the reins of power. This, of course, is not the first time that an incumbent president has ever been defeated. John Adams in 1800 had been defeated. There have been a number of times over the course of American history, most recently in 1992, when George H.W. Bush lost his bid for re-election. But never before had we seen what occurred in December and January, and especially on January 6th of 2021. Never before had there been an insurrection at the Capitol. Never before had there been a plot to try to have the vice president decide the election in favor of the candidate who had lost both the popular vote and electoral vote. I stress this because it's so important that we not think of this as normal or business as usual. 70% of Republican voters believe that Donald Trump won the election and was stolen from him, even though there is absolutely no evidence of that. Every court to consider it, state and federal, judges appointed by Republicans and judges appointed by Democrats, concluded that there was no evidence to support this. I worry that since January of 2021, 18 states have adopted laws to make voting more difficult, and that this will have an enormous effect on primaries this spring, the 2022 November elections, and then the primaries and presidential election in 2024. So I want to talk about a couple of things today. One is I want to talk about partisan gerrymandering that is occurring throughout the country and its likely effects. And then I want to talk about the Voting Rights Act and how the Supreme Court has largely gutted the Voting Rights Act, and what that's likely to mean in the coming elections, and then challenge the laws that I was just referring to. Let me start by talking about partisan gerrymandering. Partisan gerrymandering, as you know, is where the political party that controls the legislature draws safe election districts to maximize seats for that party. It's where, say, a Republican-controlled state legislature would draw state legislative districts or congressional districts to maximize seats for Republicans. Or it's where a Democratic-controlled city council, where there's partisan elections, would draw city council districts to maximize seats for Democrats. This is nothing new. In fact, it takes its name from a governor of Massachusetts early in American history, Elbridge Gerry, who engaged in this practice. But what is new is that because of sophisticated computer programs, it's possible to draw election districts with far more precision than ever before to achieve partisan gerrymandering. There have been many lawsuits to try to argue that partisan gerrymandering is unconstitutional. Initially, in a case called Davis versus Bandemere in the 1980s, the Supreme Court said partisan gerrymandering is unconstitutional because substantial dilution of voters in their ability to participate in the election. If, say, Democratic voters end up with 50% of the votes for seats for Congress, but end up with only 10% of the actual seats, then their voting strength is diluted. In 2004, in Veith versus Jubileer, the Supreme Court, 5-4, divided along partisan lines, suggested that challenges to partisan gerrymandering could not be heard in federal court. There's a great deal of litigation in the last decade, and a number of courts found that there could be successful challenges to partisan gerrymandering. But in June of 2019, in Rucho versus Common Cause, the Supreme Court said that challenges to partisan gerrymandering cannot be brought in federal court. Rucho arose in North Carolina. North Carolina is basically a purple state. It went for Obama in 2008, Romney in 2012. It went for Trump in 2016, 2020, but always by very close margins. If you would look at congressional votes in North Carolina, over the entire state, Democrats and Republicans get about the same number of votes. Republicans control the North Carolina state legislature, and they ran 3,000 different programs through a computer for ways in which districting could be done in North Carolina. They said that their goal was to find the program that would give Republicans control of 10 of 13 congressional seats from North Carolina. They picked the map that they thought was most likely to do that. They succeeded. In 2016, Republicans and Democrats got almost exactly the same number of votes across the state for seats in Congress, but Republicans ended up with 10 seats and Democrats only 3. The same thing occurred in 2018. A challenge was brought. A 3-judge federal district court found that the partisan gerrymandering was unconstitutional, and it went to the Supreme Court. The Supreme Court, 5-4, reversed. Chief Justice Roberts wrote the opinion for the court. His opinion was joined by Justices Thomas, Alito, Gorsuch, and Kavanaugh. Justice Kagan wrote a vehement dissent, joined by Justices Ginsburg, Breyer, and Sotomayor. The holding of the court was that challenges to partisan gerrymandering are, quote, a political question and cannot be adjudicated in a federal court. Chief Justice Roberts wrote the opinion for the court. He said the problem with partisan gerrymandering is it requires answering the question, how much is too much use of politics? He said the federal courts don't have any basis for answering this question. And he said, therefore, the federal courts can't hear the challenges at all. Justice Kagan responded in her dissent and said, whatever is too much, this is too much. She said there are many different ways of assessing partisan gerrymandering. She said we might simply compare the percentage of votes that a political party gets with the seats that it ends up with. If there's a great disparity and there's no other explanation, that's unconstitutional. She said in a democracy, it's supposed to be voters who choose their elected officials. So the problem with partisan gerrymandering is elected officials get to choose their voters. After each decennial census, new districts are drawn in every state for state legislatures. New districts are drawn for seats in Congress. At the local level, new districts are drawn for city councils or county boards of supervisors. After the 2020 census, when there was new districting to be done, every one of these legislatures, unless there was an independent districting commission, knew that it could draw the districts without need to fear any challenge in federal court. Now, I want to emphasize what the Supreme Court held was that there can't be challenges in federal court. There still can be challenges in state courts under state constitutions. couple of years ago, the Pennsylvania Supreme Court found that the partisan gerrymandering that favored Republicans there violated the Pennsylvania state constitution. Just in this year, 2022, the North Carolina Supreme Court found that the partisan gerrymandering there violated the state constitution. It was a 4-3 decision, with the justice on the North Carolina Supreme Court being split along party lines. More dramatic, the Ohio Supreme Court just last month found that the partisan gerrymandering of the Ohio legislature and seats in Congress from Ohio violated the Ohio state constitution. The Chief Justice of the Ohio Supreme Court, a conservative Republican, joined with 3 Democratic nominees to find that the partisan gerrymandering violated the state constitution. And so, because there can't be challenges in federal court, we will see more challenges in state courts. And the Supreme Court in Rucho versus Common Cause indicated that states could do this through their state constitutions. At the same time, there are states that have independent districting commissions. California has this. And the purpose of the independent districting commission was to take drawing of districts away from the political process and give it to an independent commission. And hopefully we'll see more states copy California and move in this direction. So that's one of the issues that I wanted to talk about. The other issue that I want to talk about concerns the Voting Rights Act of 1965. I regard the Voting Rights Act of 1965 as one of the most important federal laws adopted in my lifetime. The United States has a long, tragic history of racial discrimination in voting. After the 15th Amendment was adopted that prohibited race discrimination in voting, during Reconstruction, there was a substantial increase in Black voter participation in Southern states. But after Reconstruction, Southern states adopted a myriad of different approaches to keep Blacks from being able to vote. Voter registration in states like Alabama, Mississippi, Georgia was dismally low. That's why Congress adopted the Voting Rights Act of 1965. The Voting Rights Act did 2 things. First, it said for jurisdictions with a history of race discrimination in voting, they would need to get pre-approval, technically called pre-clearance, from the Attorney General or 3-judge federal court before changing their election systems. Congress was aware that especially Southern states were constantly changing their voting systems to disenfranchise minority voters. Do you know the game whack-a-mole, where you knock something down at one place and it pops up another? That's what Congress saw going on, particularly in Southern states. A state would adopt a new voting restriction that would disenfranchise minority voters, for it to be struck down by a court, and then another one to pop up, and another one. So as a preventative measure, Congress said, for jurisdictions that have a history of race discrimination in voting, they'll need to get approval prior to the change being implemented, and have to come from the Attorney General, a 3-judge court. There were hundreds of instances of the Attorney General denying preclearance to discriminatory voting systems. There were probably thousands of instances where it wasn't even tried because it was obvious preclearance would be denied. This was an extremely effective mechanism that would have the effect of limiting race discrimination in voting. In 2007, this was scheduled to expire. And in 2006, Congress held over 15 hearings, compiled a legislative history over 10,000 pages, documenting the continued race discrimination in covered jurisdictions. The Senate voted 98-0 to extend the Voting Rights Act, these preclearance provisions, for another 25 years. Can you imagine the Senate today doing anything 98-0? The House voted in favor of this with only 38 no votes. President George W. Bush signed it into law. But on June 25th, 2013, in Shelby County versus Holder, the Supreme Court declared the key provisions of the law requiring preclearance to be unconstitutional. It was a 5-4 decision. The justices were divided along ideological lines. Roberts wrote for the 5-person majority. Justice Ginsburg wrote vehement dissent, joined by Justice Breyer, Senator, and Kagan. In fact, Justice Ginsburg's dissent was one of the most famous opinions from her time on the United States Supreme Court. Why was the preclearance requirement unconstitutional? Usually when you read a Supreme Court opinion that declares something unconstitutional, say it violates this constitutional provision or this constitutional principle. Much harder to figure that out from Roberts' opinion. At the very end, he says that this violates the principle of equal state sovereignty, that Congress must treat all states the same. Only some states had to get preclearance. But where is that found in the Constitution? I'm not an originalist. I don't believe the meaning of the Constitution is frozen when it's adopted. But if anything is clear about the original meaning of the Constitution, it's that the framers of the 14th Amendment didn't believe that Congress had to treat all states the same. The Congress that ratified the 14th Amendment also passed the Reconstruction Act and created military rule over former rebel states. What's clearer than that Congress didn't believe that the Constitution required that all states be treated the same? The result of Shelby County is that no longer do any jurisdictions have to get preclearance. Immediately after the decision, North Carolina, Texas put in effect laws that had been denied preclearance that have a discriminatory effect. I said there were two things the Voting Rights Act did. One was it required jurisdictions with a history of race discrimination to get preclearance. The other thing that the Voting Rights Act did is found in Section 2. It prohibits state and local governments from making election practice systems that discriminate against minority voters or against certain language minorities. In 1982, Congress amended the Voting Rights Act to make clear that proof of a discriminatory effect against a minority group is sufficient to establish a violation. There doesn't have to be proof that there was a discriminatory intent. On July 1st of 2021, in Brnovich versus Democratic National Committee, the Supreme Court tremendously weakened the provisions. I think it's fair to say gutted the provisions of Section 2 of the Voting Rights Act. Brnovich rose in Arizona. It involved two provisions of Arizona law. One said that in order for a vote to be counted, it had to be cast in a person's own precinct. The other provision said that an absentee ballot had to be turned in only by the voter or a family member of the voter. It couldn't be turned in by anybody else. The United States Court of Appeals for the Ninth Circuit, in an en banc decision, found that both provisions had a racially discriminatory effect and violated the Section 2 of the Voting Rights Act. This is the former provision, the Ninth Circuit said, evidence demonstrated that polling places were changed and moved much more often in communities of color than in white communities, and thus would have a discriminatory effect against minority voters. As the latter provision, the Ninth Circuit said, especially there are Native American communities in Arizona that don't have access to mail services, and restricting the ability to turn in absentee ballots will have a discriminatory effect there. The Supreme Court, in a 6-3 decision, reversed the Ninth Circuit. Justice Samuel Alito wrote the opinion for the court, joined by Roberts, Thomas, Gorsuch, Kavanaugh, and Barrett. Here, Justice Kagan wrote a fiery dissent, joined by Justice Breyer and Sotomayor. You see that the shift from Justice Ginsburg to Justice Barrett is why the earlier case was 5-4 and this one is 6-3. Justice Alito said that in deciding what violates Section 2 of the Voting Rights Act, it's important to look at the totality of the circumstances. And he said, we want to give guidance to the lower courts. So we're going to indicate 5 guideposts that they should use in deciding whether or not there's a violation of Section 2 of the Voting Rights Act. He said, first, how great is the burden on voting? He said, all regulation of voting has some burden. He says it has to be a significant burden. And he didn't believe the Arizona law created a significant burden. Second, he said, how does this burden on voting compare to those that existed in 1982? Why 1982? Because that's when the Voting Rights Act was last amended. And he said there were a lot worse restrictions in 1982 than today. He said, third, how large is the discriminatory effect against minority voters? He said, many laws have a discriminatory effect against racial minorities. He says, it has to be a significant discriminatory effect. And he didn't believe that that existed here. Fourth, he said, what are the other ways of voting in the state? He said, the more there are other ways of voting, the less any particular restriction is going to violate the Voting Rights Act. He said, there's a lot of other restrictions in the state, so we shouldn't be troubled by this one. And fifth, he said, you have to balance and ask, what's the state's interest? And he says the state especially has an interest in preventing fraud and that justifies the law. He put all of this together and said, no violation of the Voting Rights Act. Justice Kagan in her dissent lamented the noble promise of the Voting Rights Act being gutted by the Supreme Court. She said, none of these 5 factors are found in the statute. There's nothing in the statute about balancing the state's interest in running fraud against the burden on voting. That's just made up by the court. Conservative justices usually say to follow the text of the statute, but here they're making things up that aren't in the text of the statute. She said many states are adopting laws that are meant to decrease voting and they'll have a disproportionate effect on minority voters. She pointed to laws that had already been adopted at that point in Georgia and in Texas. And she said, this is going to make it so much more difficult to challenge those laws. I think that she's right there. As I said, 18 states have adopted laws, and these laws are meant to decrease voting, making it harder for people to vote, making it harder to vote, say, absentee. These laws will have a disproportionate effect against voters of color, but it's going to be far more difficult to bring a challenge in light of the Supreme Court's decision in Brnovich. I think in this way, Brnovich is going to have a major effect as we look at the November 2022 or November 2024 elections. I want to mention one other development with regard to Section 2 of the Voting Rights Act, a very troubling one from just a few weeks ago. It involves the drawing of congressional districts in Alabama. And though Alabama is about 27% Black, they drew congressional districts so that Blacks would be the majority in only one and have a much smaller percentage than 30% of the seats in Congress. A 3-judge federal district court, 2 judges appointed by Donald Trump and 1 by Bill Clinton, found that this had a racially discriminatory effect and violated the Voting Rights Act. The judges enjoined this from being used and said, draw a different map. The United States Supreme Court, in a 5-4 ruling, stayed the 3-judge district court order, allowing that Alabama discriminatory map to be used in the May primary and the November 2022 elections. The 5 in the majority were Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. Kavanaugh wrote an opinion explaining this, and Kavanaugh said, there's a principle that federal courts should not interfere soon before an election. It comes from a Supreme Court decision in 2007, Purcell versus Gonzalez. It's even sometimes called the Purcell principle. He said, this is too soon before the Alabama election, so the federal court shouldn't get involved. Chief Justice Roberts, well as Justices Breyerson and Kagan, dissented. Justice Kagan said that no one here questions the fact-finding or the application of law to fact by the 3-judge court. Chief Justice Roberts made that point as well. The only thing that the majority says is this is too close to the election. But Justice Kagan said, the election's not until May. That's plenty of time to redraw the districts. And what's very frightening then is that often it will be impossible to bring a legal challenge to how districting is done no matter how egregious the race discrimination, for the first election, because it will always be close enough to the election that the Supreme Court will say the federal court can't be involved. It certainly gives legislatures the incentive to engage in blatant race discrimination and districting, knowing that at least they'll get away with it for the first primary and the first general election. And the Supreme Court is allowing the discriminatory districts to go into effect in Alabama and is going to hear the case as to whether it violates the Voting Rights Act next fall. Too late to change anything for the November 2022 elections. There are two narratives about voting in the United States. The Republican narrative is that voter fraud is a significant problem, and we need laws like the Arizona law from Brnovich to deal with the problem of voter fraud. The Republican narrative denies that there's significant race discrimination in voting. The Democratic narrative is that voter fraud is largely unproven, that the real problem is efforts to suppress minority voting. The Supreme Court has 6 justices appointed by Republican presidents who choose the Republican narrative, and 3 justices appointed by Democratic presidents who choose the Democratic narrative. And that's where we are as we approach the primary season this spring and the general election in November.
Thank you for that overview. We definitely have some questions to get to. And I guess I'll start with, since we talked about most recently the Voting Rights Act, you talked about legislation that the main, or one of the main arguments that for the case that gutted Section 5 of the Voting Rights Act was that the legislation treated states differently. What about an option that would treat all states the same and required all states to get pre-clearance? Would this be too burdensome, or would that be an option?
It would be an option. Under the court's reasoning in Shelby County versus Holder, that would be constitutional. It's also possible that a new formula based on current data might be allowed, even if it treats some states differently. One of Chief Justice Roberts' objections in Shelby County was that the 2006 extension to the Voting Rights Act didn't change the formula because two needed to get pre-clearance, and it was based on old data. Well, maybe a new formula would satisfy the court. The difficulty is getting the new version of the Voting Rights Act through Congress. I think what you suggest, the alternative I suggest, would create a constitutional Voting Rights Act and a constitutional way to pre-clearance. And the House of Representatives passed something like that. But the Republicans filibustered in the Senate, and Senators Manchin and Sinema wouldn't vote to lift the filibuster for this. So I don't see a way with the current Congress of getting voting rights legislation adopted.
For Section 2 of the Voting Rights Act, which is what the Brnovich case was addressing, is there any way, is there anything left after Brnovich? Is the only hope for the Voting Rights Act at this point to get new legislation, or are there still components of it that the Supreme Court could rely on for future cases?
Section 2 of the Voting Rights Act still exists. State and local election practices that are discriminatory effect against minority voters still violates the Voting Rights Act. What Brnovich does is make it much more difficult to prove that a violation exists and to get a remedy. But even without new legislation, there are challenges being brought under Section 2 to the laws that I was mentioning that states are adopting. The United States government is suing. It's uncertain whether those challenges can be successful in light of the Supreme Court so weakening the protections of Section 2. Once more, legislation to fix Section 2 would be wonderful, but it seems unlikely to be adopted given the current Congress and a Republican filibuster.
Under what rationale did the Supreme Court rule that the Georgia congressional map, which is believed to violate the Voting Rights Act, should be allowed to stand for the upcoming congressional elections?
The Alabama, and this is the case of Merrill versus Milligan. It's interesting, that what Justice Kavanaugh says there is that it violates the principle of Purcell versus Gonzalez for a federal court to issue an injunction soon before the election. This is why I stress that Chief Justice Roberts, in his opinion, said that there's nothing that the majority says that indicates that the three-judge court made a mistake. All the court said was that federal courts shouldn't interfere with elections soon before the election. I think it's a questionable principle. If the state or local practice is unconstitutional, that it should be able to be challenged. But even if you accept the premise that a federal court shouldn't get involved soon before the election, this was the federal court getting involved 4 months before the primary, 10 months before the general election, and still the Supreme Court said the federal court couldn't get involved.
You talked about gerrymandering not being an issue for the Supreme
Federal
Court, that it would be handled by state courts. And yet the Supreme Court is addressing a redistricting case. Can you explain a little bit about how that happens and sort of the procedure of it?
It's very important to separate racial gerrymandering from partisan gerrymandering. When the government uses race as a predominant factor in drawing election districts, it's going to face a heavy burden or violates equal protection. If there's racial discrimination in districting, that violates the Voting Rights Act. But partisan gerrymandering is different. Partisan gerrymandering is where the legislature draws election districts to maximize safe seats for a political party. There can still be a challenge to the use of race in districting. There can still be a challenge if it's claimed that districting has a discriminatory effect based on race. But what can't be challenged in federal court is partisan gerrymandering, where the legislature uses the political party as the basis for drawing districts. Now, I've presented this to you as the Supreme Court has articulated. Often in practice, the line between what's race and what's party is less clear. Blacks nationally vote about 90% Democratic. If the effort is to keep Blacks together or to split Blacks up for political reasons, is that race or is that party? So there is an intersection between the two, but it's important to note the Voting Rights Act is about when race can and can't be used in the election process. Partisan gerrymandering is when political party affiliation can or can't be used.
One more question about gerrymandering. So there was gerrymandering in New York. I guess maybe there are cases there that are coming before their state courts. I'm not personally familiar with it. Are you familiar with that? And do you have a view of what's happening in New York at this point?
I know there are challenges being brought. I don't know enough about the districting in New York to know the likelihood of challenge succeeding. But the key to remember is, and I'll go back to the distinction I mentioned a moment ago, if it's a claim that race is impermissibly used, that can come to federal court under the Voting Rights Act, or for that matter, under equal protection. But if it's a claim that political party affiliation was impermissibly used, that can't go to federal court, but it can be brought in state court under the state's constitution.
I want to shift gears a little bit and talk about the court itself. And I have a bunch of questions on this. We'll start with, do you see philosophical differences among the 6 conservative justices?
Yes, I think that 5 of them, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, are more conservative than the 6th of them, Roberts. If you'd look along an ideological continuum, I think you'd see further to the right, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. And Roberts, to be sure, is right of center, but not as conservative as they are. And so, for example, in the Alabama districting case that I mentioned, Merrill versus Milligan, Roberts joins with the 4 liberal justices. It's another area, but when it came to whether or not the Supreme Court should issue a preliminary injunction against Texas SBA, law that prohibits abortion for the 6th week of pregnancy. Roberts joins with the liberal justices in wanting to grant an injunction, but the conservative justices, those 5, were in the majority. I can give you more examples of that as well. In fact, if you look at an ideological continuum from far right to far left, I think there's 5 justices that are very far right. Roberts, who's a moderate conservative, Breyer and Kagan, who are more moderate liberals, and Sotomayor, who's a very staunch liberal, as was Ginsburg before she died.
What are your thoughts about expanding the court? And are there reasonable goals for doing that? Does that have any chance of happening, especially in today's political climate?
It has no chance of happening because Republican senators would filibuster it, and there's no will among the Democrats to have a majority to change the rules with regard to the filibuster. I personally would favor expanding the size of the Supreme Court. The size of the Supreme Court is not in the Constitution. It's set by federal statute. It's varied between 5 and 10 over the course of American history. 9 is a historic accident. Andrew Johnson was a terribly unpopular president in the late 1860s. In fact, he had just been impeached by the House of Representatives, and Congress didn't want him to be able to fill a seat on the Supreme Court. So Congress passed a law saying the next time there's a vacancy on the court, we'll just eliminate that seat. And it's been 9 ever since. I think there's a tremendous ideological imbalance in the current court. Let me put it this way. Between 1960 and 2020, there were 32 years with a Republican president and 28 years with a Democratic president, almost exactly even. It will be even in 2024. But between 1960 and 2020, Republican presidents picked 15 justices to the Supreme Court, and Democratic presidents picked only 8 justices to the court. Or to put it another way, Donald Trump picked 3 justices in his 4 years as president. Jimmy Carter, Bill Clinton, and Barack Obama served a total of 20 years as president, and in those 20 years, they picked only 4 justices. And so I would favor expanding the size of the Supreme Court to create more ideological balance. But it's academic. Any such bill is sure to get filibustered by Republicans and thus has no chance of passage.
What about changing terms, like adding term limits or something? Same idea, no chance?
I would favor 18-year non-renewable terms for Supreme Court justices. Thankfully, life expectancy is a lot longer now than it was in 1787. In 1787, when the Constitution was written, average life expectancy was 36 years old. Clarence Thomas was 43 when he was confirmed for the Supreme Court in 1991. If he stays on the court until he's 90, the age was just as John Paul Stevens retired, Thomas will be a justice for 47 years. So this doesn't sound ideological. Elena Kagan was 50 when she was confirmed. If she remains till she's 90, she'll be a justice for 40 years. Or take one of the newest justices, or the newest at this point, Amy Coney Barrett. She was 48 years old when she was sworn in on October 26, 2020. If she stays on the court until she's 87, the age which Justice Ginsburg died, Barrett will be a justice until the year 2059. This is too much power in one person's hands for too long a period of time. I would favor 18-year non-renewable terms, but I think it would take a constitutional amendment. And while I think there's bipartisan support for this, Texas Governor Rick Perry campaigned on this when he was running for president. Liberals have advocated it. I don't think there's a constituency that cares enough to do the hard work necessary to get a constitutional amendment adopted.
I'm going to shift a little bit, but still talking about the court in general. What is your assessment of Ketanji Jackson Brown, and do you believe she'll be confirmed without any issues?
Everything I know about her is that she's terrific, and I think she will be confirmed without any issues. She has sterling credentials. Resumes in law don't get better than hers. Graduate of Harvard College, Harvard Law School. She clerked on the Federal District Court for Patty Saris, terrific judge. She clerked on the United States Court of Appeals, First Circuit for Bruce Selya, terrific judge. She then clerked for Justice Stephen Breyer on the Supreme Court. She worked in a variety of practice settings, including as a public defender. She became a federal district court judge in 2013 and has a terrific reputation, and became a federal court of appeals judge just last year. So far, the only things that have been said about her is Republican senators saying she's a far left nominee, but there's nothing in her record to support that at all. So far, nothing has come out that would indicate any problem with regard to confirmation. So I expect that it was with all confirmation of the Supreme Court, most Republicans will vote against her, but I think there's going to be some Republicans who vote in her favor, and I think she can be easily confirmed.
Do you think having her on the Supreme Court will change the tenor of the court? And would it, I mean, still, obviously, it's going to be a 6-3 split, but would it have any effect on the decisions, just having her voice on the court?
It's still a 6-3 court, and the court is going to often split 6-3. Last year, there were 54 cases decided with signed opinions after briefing or argument. 12 were 6-3 decisions. And so many of those were the 6 conservatives on one side and the 3 liberals on the other. But I don't want to minimize her impact. In part, it's not what she's going to mean in 2023. It's what she's going to mean in 2040 or 2050, when the composition of the court may be very different. Also, she brings different experiences than other justices, and that might in some cases sway the other justices. She's only one of 2 justices who will have had experience as a trial judge. Sonia Sotomayor was the other. She's the only justice who will be on the court who has substantial experience representing criminal defendants. She's the only Black woman on the court when she's confirmed. And all of this, in some cases, might cause her to persuade some of her colleagues who don't have those experiences.
I'm going to circle back to more voting rights law questions. Wouldn't it be terribly difficult to prove racial bias versus political bias in the redistricting cases where you said, you know, only one of those is the Supreme Court allowed to address? How can you possibly extract them from each other?
The Voting Rights Act is amended, says, if there's proof of a racially discriminatory effect, that's sufficient to establish a violation of law. Brnovich is so important because it makes it very difficult to prove the racially discriminatory effect.
Are you aware of how the California districts that were previously under pre-clearance requirements have fared since the Shelby ruling?
I don't know. And of course, no districts any longer, no state or local governments any longer need to get pre-clearance for anything.
Mm-hmm. So I want to ask a few more questions specifically about vote deprivation and disenfranchisement laws. Like, what is the threshold for laws to trigger the Voter Rights Act when you're talking about something that's not specifically, it's not necessarily based on race, but it certainly has more of an impact on certain races? I mean, obviously we've seen that the 6-court majority wants to tease out what they can tease out and pull it away from the racial questions.
Laws that keep some citizens voting generally have to meet what's called in law strict scrutiny, have to be necessary to achieve a compelling purpose. So when Virginia said in order to vote, you have to pay a tax, it was a $1.50 tax, the Supreme Court said, no, that's going to keep some citizens voting. That denies equal protection. In addition, the Voting Rights Act is specifically focused on race discrimination voting. says there can't be any election practice system that have a discriminatory effect against minority voters. And Brnovich is important because Brnovich makes so much more difficult to challenge this. Let's look at examples. What states are trying to do is things like decrease absentee ballot availability, decrease the placement of polling places in especially communities of color, communities where there's a large number of Democratic voters, even preventing people from being given food or water when they're standing in line to vote, when they're having to stand for long periods of time. Voter ID laws that require that in order to vote, you have to show photo ID. All of these requirements have been proven to have a much greater effect on voters of color than on white voters. But they're going to be very difficult, if not impossible, to challenge, given how the Supreme Court decided Brnovich.
Can you speak a little bit about other cases that are coming in the pipeline that might be relevant for voting rights or other issues that might be of interest to our audience?
Well, let me address the latter. This is a momentous year in the United States Supreme Court. The Supreme Court has a case before it, argued on December 1st, Dobbs versus Jackson Women's Health, where the issue is whether to overrule Roe versus Wade. And I think there's a great likelihood that there are now at least 5 votes on the court to overrule Roe, and that will happen this spring. There's New York Rifle and Pistol Association versus Bruin that involves whether there's a constitutional right to have guns outside the home and to have concealed weapons. There's Carson versus Macon as to whether the state has the obligation to fund parochial school education when it funds secular private education. And then the Supreme Court has granted review in some major cases for next term. I already mentioned Merrill versus Milligan, the Alabama voting rights case. But the Supreme Court has granted cert in 2 cases, one fair admissions versus Harvard University and one fair admissions versus University of North Carolina, that involve whether college universities can continue to use race as a factor in admissions to the benefit of minorities. There's a case called 303 Creative LLC versus Solanas that involves whether or not a business can refuse to serve same-sex couples in violation of state anti-discrimination law. I think all of this is going to show what it means to have such a conservative court now and for the foreseeable future.
What's the remedy for that, in your opinion? I mean, if we can't expand the court, we can't make any meaningful changes to the court, what can we do?
To start with, to remember that elections have enormous consequences. This seems so important as I'm talking to the League of Women Voters. And the reality is that the current court is because of the 2016 presidential election. Had Hillary Clinton won in 2016, and had she picked 3 justices, we wouldn't have the issue now before the court of whether to overrule Roe versus Wade. Brnovich wouldn't have come out the way that it did. So it's important as we face 2022, 2024 and beyond to keep that in mind. Why 2022? If the Democrats lose the Senate, then President Biden's not going to get any federal judges confirmed in his last 2 years of office, including if there's another vacancy on the Supreme Court. He's not going to get anyone confirmed. Mitch McConnell has already made that clear. And of course, whoever's president gets to pick justices for the court, and that's our best remedy. I think that it's also going to be necessary to look to other forums. It's going to be necessary to look to state courts in some instances, whereas previously we've gone to federal court. Partisan gerrymandering being an example of that. It can be challenged in state court or state constitutions, but not under the United States Constitution in federal court. Sometimes it's going to be necessary to go to the political process. I would hope that more states would create independent district commissions like California has done.
So you maybe sort of already answered this, but we're in our last 5 minutes, and I always like to wrap up with this one final question, which is, what is the most important concrete step that each of us can take to protect our democracy?
vote, get other people to vote, work hard at the state by state level to make sure that voting is as easy and as safe as is possible. Be part of organizations that are challenging the laws that are restrictive of voting, to work to get Congress to adopt new voting rights legislation to cure and overcome Shelby County and Brnovich. And so I think all of these are crucial things. And what I want to stress is they're nonpartisan. Nothing I've said is about how people should vote. It's just about being sure that people get out to vote and that the votes get counted fairly.
And I have to say, we're going to wrap up here, but you just highlighted the main part, the main component of our league members, our league mission of empowering voters and defending democracy. So I really appreciate that. I want to be mindful of time. I appreciate all of the thoughtful questions and information that I've personally learned. I'm very grateful to you, Dean Chemerinsky, for joining us and taking the time to be with us today. Thank you so much. And thank you again to everyone else for joining us today. Feel free to share the YouTube link to the recording of this live stream with friends and family. Again, subscribe to our channel and join our mailing list to get notice of future events. This officially ends our program. Thank you so much for joining us.
Thank you.